Good day to you and welcome to another Paddocks Club video tutorial. Today I want to talk to you about a new case which Kate has put up in the library. It is the case of Andre Grundler NO versus the Flamingo Heights Body Corporate, and it deals in specific terms with a case of administration. The basics, if you're at all interested in the administration of troubled bodies corporate, are that an administrator who after 36 months had not made a lot of progress in rehabilitating a scheme was applying to the court to have his period extended. The court had a good look at all the facts and came up with some startling conclusions. The first was that the body corporate was much worse off now than it had been when the administrator took over. In fact, a large debt, 158,000 rand, which had been owing to the municipality and was a major cause of the body corporate going under administration, had in fact been written off. Nonetheless, the body corporate now owed almost 200,000, much of that to lawyers and to the administrator himself. And the court looked at the whole situation. It also looked at the fact that the body corporate's members had now started to work together quite separately and independently from the administrator, and that they vigorously opposed the extension, suggesting that the administrator was perhaps getting hidden profits and various other things. Now those claims were never tested in this particular application, but I think it was significant that the judge took into account these things and decided no, he was not going to extend the period of the administrator's tenure. He looked specifically at the test. The administrator had suggested that the body corporate needed to be rehabilitated, to have a clean slate before it could be handed back to the owners, whereas as the judge looked at the Sectional Titles Act and said no, self-administration is what was intended, so as long as there's a reasonable prospect that these chaps can manage their own affairs, that the scheme should be given back to them in their attempt. And these creditors could of course all bring applications in court to prove their claims. The other interesting thing was that the judge looked at the nature of the application which had been made by the administrator in his official capacity, nomine officio, and said, you know, if I give you costs, in fact the body corporate's going to end up paying all these costs. So he didn't. He awarded the costs against the administrator in his personal capacity, which meant that he relieved the body corporate of those particular costs, but he did give people an opportunity to object to his orders in a short period, 10 days after the judgment, leaving the gate open for somebody to come back and give a good argument as to why that wasn't fair. A very interesting judgment, and one that I think anybody interested in the administration of sectional title bodies corporate should read carefully. We can of course discuss it in the discussion forum. Thank you for joining me in this Paddocks Club video tutorial.